view of the Honorable the Attorney General, the Chief Legal Advisor of the Government of the Republic of Kenya, it has not been demonstrated in any of the petitions argued before you that there was a violation of the constitutional rights of your petitioner, and it has not been demonstrated that this court is vested with a jurisdiction to review anything else other than that. My Lord, it's common ground among all counsel here that impeachment is not an ordinary constitutional proceeding. In the words of the Supreme Court of the Philippines, it is a sui generis proceeding, a constitutional measure designed to protect the state from official delinquencies and its political in character. I know it's been submitted by my learned friends repeatedly that these impeachment proceedings are not of a political character. In fact, impeachment proceedings globally are political in character. And there is an article referred to in our submissions, which my lords will find, which is an article that summarizes global trends in impeachment proceedings. In fact, here in this country, the very point that my learned friends deny has been consistently affirmed by our courts. Let us see what the court said in Kaweria Mwangaza versus the County Assembly of Meru and another. Justice Edward Mureithi, your learned distinguished colleague, sitting in Meru. There are three distinct features about impeachments and other accountability mechanisms. First, and my learned friends have made heavy weather of this, mandatory public participation. But I want to pause there and to remind ourselves, the public is not participating so that it may make the decision whether to impeach or not. That is not the work of the public. The public is participating so that this political process may be informed. Number two, strict constitutional timelines. And three, bicameral supermajoritarian requirements, both at initiating it and at the removal. This is not accidental draftsmanship. These are deliberate constitutional choices that vest the impeachment power firmly and finally in the hands of Parliament, and not the courts, in the hands of Parliament. Why? Because Parliament is elected. Parliament is an elected body. Political accountability is to an elected body that we call Parliament. The courts are not elected, and that is deliberate in our constitutional democracy. So we cannot have a counter-majoritarian situation where the elected representatives make a decision which is then reviewed for policy purposes by a non-elected branch. And I will be making it very clear in a very short time. That is not to say that the High Court does not have constitutional oversight over Parliament. It does. The High Court has constitutional oversight over Parliament. What does that mean? That this court, and that's why we are here this afternoon, must satisfy itself that the rights of the petitioner were respected. What can't this court do? This court cannot say, like you have been invited, that why does that particular MP say that this man was rude to another man, therefore he's impeaching him? That is beyond what you can investigate. Kenya, this our beloved republic, we have put a threshold for impeachment that is one of the highest in the world. We have made it more difficult to impeach than any other country that we can think of. You can look at paragraph 66 of the second respondent submissions, and it will illustrate that our criteria is one of the most demanding in the world. Look at the United States that prides itself as the biggest democracy in the world. You require only a simple majority in the House of Representatives to initiate impeachment. In Kenya, you require 2/3, almost an impossibility. Under the old constitution, you require 2/3 to change the constitution. It's a very, very, very high threshold. In the proceedings now before you, my lords, we have 282 members who voted in favor. 44 voted against. That is not a partisan squeak. That is a constitutional supermajority of extraordinary proportions. Some explanation has been given as to why Parliament votes in this way. We have no evidence. No evidence has been brought before you. It's political opinion, and whoever holds it is entitled to it. Let me come now, my lords, to what is your duty in the humble submission of the Attorney General of Kenya. What is the duty of the court when we have reached this point? Should this court proceed to a merit review of the impeachment? Should it relitigate the proceedings as the petitioners very boldly demand? Our respectful answer is that you should not and you cannot. You must resist the invitation to turn these proceedings into a merit review of the impeachment. If Parliament was full of wise men, would they have reached this decision? If the Senate was full of angels, would they have reached this decision? That is one question you should not be tempted to answer. What, in our very humble view, should you do, my lords, as your duty? Your very simple duty is to ask yourselves, was there a violation of the constitutional rights of the petitioner? That's all. Was there a violation of the constitutional rights of the petitioner? That's a narrow, very, very narrow inquiry. This is not my personal opinion. It is the settled jurisprudence of the Republic of Kenya. It is the settled jurisprudence of the Republic of Kenya as enunciated by the Supreme Court of Kenya, the highest court in our republic, in the case of Sonko versus the County Assembly of Nairobi City and against 11 others. This is what the Supreme Court said, and I beg your indulgence to read verbatim. Likewise, in Justice Kariuki Mate and another versus Martin Nyaga Wambora and another, this court signaled that it would be reluctant to question parliamentary procedures as long as they did not breach the Constitution, and that the mandate of the court is restricted by the doctrine of separation of powers to deciding on matters of individual rights and fundamental freedoms, and to inquire into how the County Assembly and the Senate perform duties in which they alone have the discretion, or to review the merit of the decision by the County Assembly to impeach the governor. What does this mean in practical terms for today's proceedings? This court is called upon not to review whether the charges against the first petitioner were approved. not to assess whether the evidence was sufficient, not to determine whether Parliament reached the correct conclusion. This court is called upon only to evaluate whether the first petitioner's constitutional rights to due process were compromised, and nothing more. So heavy weather was made by my very honorable and distinguished learned friends, led by my very own friend, the Honorable P.K. Muigai. Heavy weather was made of all manner of allegations relating to process, who initially was to bring the petition, who ended up bringing the petition. All those are irrelevant. Only one thing is relevant. Were the petitioner's constitutional rights to due process compromised? From where we sit, I am instructed by the Honorable the Attorney General to advise the court that no violations have been demonstrated in the petitions now before you. Further, I wish to submit this. The evaluation you will make, my lords, as to whether the petitioner's constitutional rights were compromised is not an abstraction. It must be anchored in the constitutional text itself. The petitioners must demonstrate that the constitutional right that was violated is this one and that one and that one. No generalities, no obstructions, specifics. This is what we are commanded to do by Article 151, Article 152, Article 144, Article 145. Article 152 provides that the provisions of Article 144 and 145 relating to the removal of the president shall apply mutatis mutandis. We must thank God for a little Latin still left in the Constitution. There was a submission made, unless I misunderstood it, that there exists only a provision for the impeachment of the president and none for the impeachment of the deputy president. Nothing could be further from the truth, because Article 144 and 145 apply to the removal of the president mutatis mutandis. It is therefore, my lords, Article 144 and 145 that we find the standard. That is where we will find the standard of how the petitioner ought to have been treated. In our very humble submission, my lady and my lords, this petition must fail. This petition will fail not because the first petitioner's concerns are not important. They are very important. But because the remedy he seeks is constitutionally unavailable. What does he ask the court to do? One, he asks you to reopen and re-examine the impeachment proceedings. You have no jurisdiction to do that. He asks you too to re-evaluate the evidence placed before the National Assembly and the Senate. You have no jurisdiction to do that. Three, he wants you to determine whether the constitutional threshold for each ground that he faced was met. Meaning, he's asking you to rehear the proceedings and reconsider the evidence. You have no such jurisdiction. 5, he wants you to quash the resolution of both houses and declare his impeachment null and void. So he's asking you to sit as a court of appeal on the decisions of the National Assembly and of the decisions of the Senate. That is exactly what the Supreme Court in the Sonko case has said no court should do. So my learned friends are flying into a wind, a headwind that they cannot overcome. What they want has already been declared by the Supreme Court as not able to issue from this court. When we look at Article 144, sub-article 8, which applies mutatis mutandis to the Deputy President by virtue of Article 150, sub-article 2, that is the situation the Constitution itself sought to foreclose. I know you will be told, and have already been told, and I've been in your court long enough to know that you've been told this many times. The spirit of the Constitution. Before we look for the ghosts and the spirits of the Constitution, we must look at its plain language. The language of 1448 provides finality to the Senate's decision. On the night that the Senate carried out its vote, your petitioner stood impeached. It did not await any other action by any other body or authority. So Article 1448 provides the finality of the Senate's decision. It's not subject to appeal or review on the merits. On the merits. To accept the petitioner's invitation to sit as an appeal court would be a violation of our Constitution and the law. Now, I want to refer you to a very well-reasoned decision of the Court of Appeal. Justice Visram, Justice Kome, Justice Otieno Odek, and they were making a point with admirable clarity on this point. And they said this: in the sequential steps identified above, courts have neither been vested with jurisdiction to initiate a motion, consider a resolution, nor to hear the charges leveled against the governor. The constitutional and statutory mandate to initiate and consider a motion to remove a county governor is vested in the county assembly and the Senate. Insofar as the process of the removal of governor from office is concerned, the province of the court is solely to decide on the rights of individuals and not to inquire how the county assembly performs duties which they have discretion in. Same point as in the Sonko matter. This court, all courts, have no jurisdiction to do a merit review of the decision of either the National Assembly or the Senate. This point had equally been made earlier, rather later, in Mumo Matemo versus the Trusted Society of Human Rights, Keka for 2013, by the Court of Appeal, a very strong Court of Appeal, William Ouko, Gatembu Cairo, and A.K. Murgo. And this is what they said, addressing the specifics of the separation of powers doctrine. Separation of powers does not only proscribe organs of government from interfering with the other's function, it also entails empowering each organ of government with countervailing powers which provide checks and balances. There must be judicial, legislative, and executive deference to the repository of this function. The word they use there is very important: deference, to give due respect, to give due respect to the decision of another. We in the judicature must give due respect to the ambit of Parliament and to the ambit of the executive. That's what our courts are saying. Why shouldn't you accept a merit-based review of the decision placed before you. Let me give you a hypothetical of why that can create a lot of chaos. If you assumed a merit jurisdiction, what would stop the National Assembly, represented here by my very good friend Eric Gumbo, appealing to this court against the Senate's decision to acquit on the 6 of the 11 grounds? Remember, your petitioner is acquitted on the major grounds. If he himself can come on appeal to you, the National Assembly can come to you on appeal on his acquittal. That is not what the drafters of our Constitution intended. They did not intend to have you, my lords, sucked into political disputes by politicians within their political organs, which is Parliament. There is another question which is important. I know there is no unanimity on this question, but in my own view, it's a very important question. And this is the doctrine of the political question. I know after 2010, the popular opinion became that any person at any time over whatever grievance he has can approach the court. We removed the rules on standing. You don't have to show how you are related to a matter. So the county government of Meru and the county government of Isiolo, they negotiate for many years a water sharing agreement. And on the day they're about to sign it, a man from Dumberi rushes to the High Court in Kiambu and says, stop that agreement. Who is he? How is he related to Isiolo? How is he related to Meru? Nobody knows. He wants an injunction. I think the rules about standing are common sense rules. And therefore, the political question doctrine, the doctrine that there are issues, there are controversies that are not amenable to the judicial process. It's a rule of common sense. There are processes that are not amenable to the judicial process because they are largely raise political controversies. Let me go back to the Supreme Court of Kenya in Sonko 2022 at paragraph 110. In considering applications to review decisions of other branches of government, courts should strive to achieve a balance between their role as custodians of the Constitution and the rule of law, including an obligation to respect what Parliament is constitutionally required to fulfill. To respect, again, the doctrine of deference. Parliament will have the discretion and the power to regulate its own affairs. The courts will be slow to interfere with the exercise of that discretion, end of quote. The Supreme Court returns to this issue yet again in the case of Cabinet Secretary for the National Treasury versus Okoiti and 52 others. What does it say? Considering the discretion vested in Parliament in fulfilling its constitutional duties under the values and principles of governance outlined in Article 10.2 of the Constitution, the role of the courts is limited to reviewing whether the measures put in place by Parliament are reasonable and in conformity with the Constitution and the law. In other words, Article 165 does not confer to this court unlimited jurisdiction. It grants supervisory jurisdiction, not appellate authority over Parliament. This court may inquire into whether the procedure prescribed by the Constitution was followed and whether the first petitioner's rights were respected. It cannot inquire into whether the charges were proved, whether the evidence was sufficient, or whether Parliament reached a correct decision. The essence of that is a merit review, and it is expressly. Let me return to the case of Wambora, and this is what the Court of Appeal says, quote, "The province of the court is to decide on the rights of individuals, not to inquire how Parliament performs its discretionary duties," end of quote. My lords, my lady, I want to come to my second last structural point, which I think is a very fundamental one. Impeachment does not merely sit at the outer boundary of this court's supervisory jurisdiction. It does not sit at the outer boundary of this court's supervisory jurisdiction. It falls squarely within the domain of non-justiciable political questions. To the extent that the petitioners are arguing merits, that's a political question, and is covered by the political question doctrine. The Supreme Court of the Philippines, we return back to its case, Sara Duterte. You will recall, my lords, she was the vice president. She was facing impeachment, and she went to court for protection against that. This is 2025, last year. Her father was the former President Duterte, now unfortunately at the ICC in The Hague, facing some charges, but that's beside the point. What the Supreme Court of the Philippines says, and I quote, "The court will not encroach upon matters that rightly fall under the authority and wisdom of a co-equal branch, or matters classified as political questions. The court will thus not delve into the merits of this impeachment complaint." Mr. Duterte was sort of asking the court to find that the charges were not tenable, they were not brought in good faith, and so on. The court said, that's not our work. Why should this court find that these petitions before you fall within the reasoning of the Supreme Court of Philippines decision in the Duterte case? For three reasons. First, impeachment is textually committed to Parliament. Articles 145 and 150 vest the impeachment power in the National Assembly and the Senate. Not in this court, nor any other court. The constitutional text is clear. It makes no provision for judicial participation in the impeachment determination. That silence is not an oversight. It is a deliberate allocation of authority. Secondly, we have to look at the criteria that the Constitution itself, by extension, the people of the Republic of Kenya, wrote into that document. It is, quote, gross misconduct. 2, gross violations of the Constitution. 3, serious reasons to believe. These are not judicial, they are not judicial evaluation standards. They are political evaluation standards. If your peers vote that they believe that your conduct is gross, if your peers think that your conduct is gross, then it is gross. Because the Constitution says, when we know whether you have acted in a gross way, we will not ask anybody, we will ask your peers. It is not what a judge would think. A judge would say, this has to be proved to a high standard. It's in our business, my lords, your business, our business, we always say that if you make, for example, an allegation of fraud, that is a very serious allegation. The standard must be high. That's not the way the political class approaches these matters. When they are asked, has this man behaved in a gross manner? They are answering a political question. They are not answering a legal question. So, when a court attempts to assess whether conduct amounts to gross misconduct, as you've been invited to do by my learned colleagues for the petitioner, then the court is not adjudicating anymore. You are not being invited to adjudicate. You are being invited to substitute the Parliament's opinion for yours. That is a dangerous path that flies right against the doctrine of the separation of powers. The Constitution doesn't allow it, and there is a very good reason it did not. Third, and this is probably the most telling, the outcome of impeachment depends on political judgment. It depends on the Senate's collective assessment or whether the conduct of the holder of a constitutional office has fallen so far below the standard demanded of that office to warrant the termination of a popular mandate. That judgment is entrusted to elected senators, answerable to the people, and not to judges. If the people believe that your petitioner was wrongly impeached, they will not vote for these senators at our next election. They will say, you were part of the people who treated so-and-so badly. So they have a political remedy, not a judicial remedy. My lords, consider what your petitions are asking you to do. They do not only allege that a procedural step was skipped or that a specific right was violated, but all they tell you is that something wrong happened. Why? Because had something right happened, these are not impeachable grounds. Inviting you now to deep dive into the case and look at the granular and then ask whether Senate acted responsibly. We seek to persuade you that that is not a path that this court should take, because the Constitution forbids it, and because binding precedent by the Supreme Court and the Court of Appeal prohibit it. In the Philippines, the court offered a further caution for the court to bear in mind, that the court has to distinguish between two failures of judicial duty. The first is the failure to exercise supervisory jurisdiction where a genuine constitutional violation can be identified. That can be one area. However, the other one is the failure of restraint that results in courts purporting to review the merits of impeachment proceedings. So, my lords, you are between the devil and the sea. If there is a constitutional violation of the petitioner's rights, your scrutiny must be enhanced. But if you do not find any of that, then you must not take any other step, because that other step would be to review the merits of how Parliament got to where it did. The Philippine court was very emphatic that I wish to make two other points. The constitutional architecture that the framers finally agreed on must be respected. And in my very humble submissions, what your petitioners are asking you to do is to recognize a judicial veto to impeachment. A judicial veto to impeachment. I think that that would be a massive judicial overreach that would destabilize the separation of powers in our own republic. I now come to one last point, and this point relates to the presidential prerogative to nominate the deputy president. I think, again, the language of 1491 is very, very self-evident. And it says this: within 14 days after a vacancy in the office of the deputy president, the president shall nominate a person to fill the vacancy, and the National Assembly shall vote on the nomination within 60 days after receiving it. That is what the Constitution requires. In fact, if by the 13th day the president hasn't acted, a public interest litigator like my friend Ochieng Dudley can begin to prepare a petition to say the president is violating the Constitution because he should have appointed a deputy president. Now, even as we speak about public participation and all other things, we must remember this. The appointment of a new deputy president to replace an impeached one is not an election. It is the sole prerogative of the president that the Constitution has donated to him. The president nominates. There are only two functions here. The president nominates, says, my nominee is Mr. X, and then he takes it to Parliament, and Parliament can say no, or Parliament can say yes. Those are the only two actors. So when there is a collateral attack on my old client's IEBC, I do not understand how it is to be entertained. The Constitution does not make the president's exercise of his prerogative conditional upon his nominee being cleared by IEBC. He may do so out of an abundance of caution. He may ask, could you please tell me whether my nominee is a registered voter? He may ask the Bureau of Registration, can you please check for me whether this man is a Kenyan? He may ask the Department of Immigration, does he hold more than one nationality? That is due diligence. It is not, he's not getting clearance from them. So I do not understand the argument that attacks, although they are in the very, very, very able hands of my learned friends here, but we do not understand how that is. I therefore submit, in conclusion, that I respectfully submit, and I thank you for your time.
Thank you.